Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross Law, LLC. Meet Sarah. For 10 years, she poured her heart and soul into her dream, a thriving artisanal bakery and catering business. She did everything right, or so she thought. Her customers loved her, revenue was climbing every year, and honestly, she was crushing it. Then, on Tuesday morning, a sheriff showed up at her shop and gave her a summons and complaint that she had to sign for. She had been sued by a former customer. The complaint threatened to ruin her entire life. It claimed damages that would not only drain her business account, but also her personal savings, her home, everything. And the worst part? It was all because of some simple, common mistakes. Mistakes that with a little foresight were completely avoidable. Sarah's story, although completely fictional, isn't some rare occurrence. The reality is that somewhere between 36% and 53% of all small businesses face a lawsuit in any given year. The question really isn't if it will happen to you, but when and whether you will be ready. As a practicing small business attorney, I have extensive experience helping clients deal with lawsuits and taking the steps needed to protect their business and their personal assets. In this video, I'll talk about 5 fundamental pillars that you should build to protect yourself and your business from the kind of nightmare that Sarah walked into. We're going to turn your fear into a plan and your vulnerability into a fortress. And please, if you'd like to get more helpful tips from us, please hit the like and subscribe button below and ring the bell in order to get notifications when our next episode is posted. So let's get to it. So what was Sarah's critical mistake? It was something thousands of entrepreneurs do every single day without a single thought. She operated her business as a sole proprietorship and without a solid contract. For years, it seemed fine. The sole proprietorship was simple, easy to set up, and didn't involve a lot of paperwork. She found her contract online, and it seemed to work for her business. She even had a separate business bank account. But in the eyes of the law, there was no difference between Sarah the person and Sarah's bakery the business. They were one and the same. The lawsuit came from a former customer claiming breach of contract. The former customer owned a business, and Sarah was supposed to provide catering services at an upcoming corporate event. Sarah didn't provide the services, but terminated the agreement. Now, Sarah felt that her termination of the contract was completely justified. The client refused to cooperate with her team and refused to respond to the request for information about the number of guests attending, the location of the event, the type of food they wanted, and even when the event started. They waited for months for the customer to respond. But when the customer failed to do so, Sarah terminated the contract and kept the non-refundable deposit as outlined in the contract. But the customer and her lawyer apparently disagreed, and they filed a lawsuit. And they didn't just sue the business and want a return of the deposit, they sued Sarah and claimed that the customer suffered all sorts of damages, like lost profits, emotional distress, and all sorts of other things. Because she was a sole proprietor, every single thing she owned was on the table. Her car, her house, her personal savings, all of it was at risk. The legal shield that should have been there to protect her personal wealth just didn't exist. This is the single most terrifying risk for any business owner. Losing everything you've ever worked for, personally and professionally, all because of one dispute. The average lawsuit can cost a small business over $54,000 just to fight. And that's before you even think of settling or a judgment. For a lot of businesses, that's a death sentence. And this isn't just about customer contract issues. It could be an employee who alleges wrongful termination, a customer who slips and falls in your store, a contract disagreement with a supplier, or someone claiming you stole their intellectual property. Sarah's story is a wake-up call. We're going to build 5 pillars of legal protection around your business so you won't have to face what she did, or at least be in a better position to do so if you face a lawsuit. Think of this as your fortress. Each pillar is absolutely essential for the whole thing to stand strong. The first line of defense for every business should be its contracts, and they should be in writing. As I've already talked about in some other videos, handshake deals and verbal agreements are the enemies of a secure business. They are the breeding grounds for misunderstandings and eventually lawsuits. Every single business relationship needs to be spelled out in clear written contracts. I've talked about the types of business contracts your business needs in an earlier video, and I won't rehash them here. Sarah's problem was that she did not have a strong client or customer agreement with clear termination provisions. To qualify as a strong contract, every contract should have a couple of key provisions. The first key provision is that every contract should clearly state what each party to the contract is required to do and when they're required to do it. In Sarah's case, the contract should have stated that the customer is required to timely respond to her inquiries and provide them with critical information about the event. The next key provision is that the contract should clearly state how the agreement can be terminated by either party and the circumstances when it can be terminated. You should also consider having a cure provision which allows either party to cure or fix any errors or breaches within a certain length of time, usually 30 days, depending on how serious the problem is. The next key provision for a strong business contract is to require some kind of alternative dispute resolution like mediation or good faith discussion between the parties. This procedure would have to be followed by either party before they terminate the agreement or file a lawsuit, and it can save you a lot of time and money. And if you want to completely avoid a lawsuit in court, you can require arbitration, which is quicker and more private than a lawsuit in court. Another key provision in any strong contract is a clause that states the losing party has to pay the winning party's legal fees. This type of clause can prevent frivolous lawsuits because there's nothing worse than having to pay both parties' legal fees. Another key provision in any strong contract is a limitation of liability and damages clause. This clause limits the types of damages that a party can be held liable for in the event of a breach of contract or other legal dispute. It can also set a cap on the amount of damages that can be recovered in a lawsuit, such as the total amount paid by either party under the contract. The second pillar to protect your business is to operate your business through a legal entity like a corporation or a limited liability company, which are called LLCs. Sole proprietorships are often chosen because they are the cheapest to set up, but they provide no personal liability protection, and operating your business as a sole proprietorship is like building a house with no foundation. It leaves you personally wide open. Instead, you should create a separate legal entity for your business, like an LLC or a corporation. An LLC or corporation creates a legal wall, often called the corporate veil, between your personal assets and your personal assets. If the business gets sued, claimants can, generally speaking, only go after the assets owned by the LLC or the corporation, not your personal home, car, or savings, unless they are used for the business. Think of it this way. As a sole proprietor, you are the business. If your business or your employees mess up, you are on the hook personally. With an LLC or a corporation, the business is its own legal person. If the business or its employees mess up, the business is liable. That separation is a powerful defense, so long as you follow the rules of the entity. Now, setting up as an LLC or a corporation is a bit more involved and expensive than just starting and operating as a sole proprietor, but it's a non-negotiable step for any serious entrepreneur who wants to keep their personal assets protected. It means filing paperwork with Massachusetts or some other state and keeping up with the formalities, like keeping your business and personal money completely separate, filing your annual reports, and if you're a corporation, having annual shareholder and director meetings, and all sorts of other things. But it's worth the effort in order to keep your personal assets protected from the liabilities of the business. And seriously, don't pay for your groceries or your streaming services with your business credit card. That's called intermingling assets and can lead to piercing the corporate veil, which can demolish the very wall you've worked to build and put your personal assets at risk. The third pillar you need to protect your business is as critical as the other two: comprehensive business insurance. Many small businesses are underinsured or have no insurance at all, and that's a huge gamble. Here are some of the key types of insurance you want to consider acquiring. The first type of insurance is general liability insurance, which is a must-have for most businesses. It covers items like claims for bodily injury that may have been caused by your business, such as a customer slip and fall on your property. It also covers claims for property damage that you or your employees may cause, such as if an employee breaks a client's window while working at their home. General liability insurance also covers claims for personal injury that aren't physical, like libel or slander or other advertising injuries. The next type of insurance to investigate is professional liability insurance, which is also called errors and omissions. This type of insurance is vital if you provide professional services or advice, and will protect you if a client sues you for being negligent or failing to deliver what you promise or making a mistake. Another type of insurance to investigate is cyber liability insurance. In our current world, with all these hacks and data breaches, it's becoming essential to make sure that you're covered and protected from these losses. If you store any type of customer data, such as names, emails, payment information, personal address, social security information, you're a potential target for hackers. A data breach can trigger lawsuits and reporting requirements that cost a lot of money. This type of insurance will help you cover the cost of data recovery, notifying customers, and the cost of any legal defense. Another type of insurance to consider obtaining is employment practices liability insurance, which is also called EPLI. The most common lawsuits faced by any business are lawsuits from employees or former employees, and these are often the most expensive. This type of insurance will cover claims related to wrongful termination, discrimination, harassment, and other types of employee-related lawsuits. One important thing to note, however, is that EPLI typically doesn't cover losses related to unpaid overtime, minimum wage, or other wage and hour violations. This is a big omission and can potentially cost you a lot of money, which we will talk about in a moment, and you need to be protected from. With respect to any of these insurance policies, or any other insurance policy, talk to a qualified insurance agent to see what you might need. And make sure to review your policies each and every year. As your business grows, your risks will change, and your coverage needs to keep up. The cost of an insurance premium is nothing compared to a potential six-figure legal bill. The fourth pillar to protect your business is perhaps the most important. You need to put in place and follow good employment practices. Now, there are all sorts of gurus online who offer you opinions about what constitutes good employment practices. And they will tell you that you should do things like prioritize employee well-being, offer work-life balance, have open communications with your employees, offer comprehensive benefits, and so on and so forth. Now, all of that may be true, but none of it will prevent your business from being sued by a disgruntled employee after you let them go. In order to prevent your business from getting sued, the most important employment practice to put in place is comply with all labor and employment laws and all internal policies that you have adopted. Now, this might seem obvious, but I can't emphasize it enough. The most common lawsuit faced by a business is one from a former employee alleging that the business did not follow the law or did not follow their policies. Don't let this be you. The problem for most companies is that there are a lot of employment laws that need to be followed, and most small businesses are unaware of what's required. And why should they be? For the most part, the business owners are not lawyers. For example, in Massachusetts, there are strict requirements about when an employee has to be paid, how much they have to be paid, and when an individual can be classified as an independent contractor as opposed to an employee. These requirements are all covered by a statute known as the Wage Act. And any violation of the Wage Act can lead to a lawsuit where the individual is automatically entitled to receive 3 times what's owed to them plus attorney's fees. This creates a lot of incentives for lawsuits. So if you're in Massachusetts, you need to make sure that your business is compliant with all Massachusetts employment laws, including the Wage Act. And if your business is located in a different state, I'm sure your state has similar laws that can cause problems for your business. Speak with a knowledgeable attorney in your area to make sure that your business is compliant with all employment laws. And if your business has an employee handbook with detailed policies about how employees are promoted, hired, or fired, make sure and follow those policies with respect to each and every single employee and each and every single decision you make. If you don't follow it, the individual negatively impacted by the decision will be upset and will feel that the decision was unfair, which can trigger a lawsuit. So make sure, if you have a detailed policy about these matters, to follow it with respect to every employee and every decision you make in your business. This brings us to the other key employment practice to put in place, which is to get in a habit of offering severance whenever you're firing someone. In order for the individual to get the severance, the individual will need to sign a detailed release that releases your business from any and all claims that the individual could bring related to their employment or their firing. Firing is often a key trigger to a lawsuit. But if the individual accepts the severance and signs the release, the individual will be unable to file any lawsuit against you for damages. Keep in mind that any type of release agreement in the employment context needs to meet detailed requirements in order to comply with applicable federal and state law. So speak with an attorney about helping you to draft a severance and release agreement that you can use. The fifth pillar to protect your business is to make sure that you or your employees are not using or infringing anyone else's intellectual property without their express written agreement or permission. There are lots of ways in which business owners either intentionally or unintentionally use someone else's intellectual property. One common way is if a business starts using a business name or a logo, but it's usually a business name, and the name is the same or confusingly similar to a name that is already registered with the United States Patent and Trademark Office which is called the USPTO. If that happens, then you can usually expect to receive a cease and desist letter from the registered trademark owner that will order you to stop using the name and threaten you with a lawsuit. If you get sued for trademark infringement, the damages can be substantial, and you can be forced to disgorge any of your profits, pay a royalty, pay the registered trademark owner's attorney's fees, and all sorts of other possible damages. It's certainly not worth it, and it can be easily avoided. Before using any name, you should run internet searches on it to make sure it's available. Check to see if the domain name is available so you can buy a website for it. You should also check social media accounts to see if anyone else is already using the name. You can also look on the USPTO website to see if there's a registered trademark in the name. I'll put a link below to the website where you can run searches. To be really certain, you can also apply for a trademark registration with the USPTO before you start using the name and run a full clearance trademark search in connection with that application. A second common way that business owners often infringe on someone else's intellectual property is by downloading photos off the internet and using them on their website or in their marketing without a license from the photographer to do so. This violates the photographer's copyright, and if it's registered, you can be sued for copyright infringement. Damages for copyright infringement are also substantial. Statutory damages range from $750 to $30,000 per work that is infringed, or you might also owe the actual damages suffered by the photographer plus any profits that you made from use of the photo. This is again not worth it and can be easily prevented. Only use photos that you have a license for or don't require a license or royalty to use. There are plenty of locations online where you can find royalty-free photos or where you can specifically purchase photos with a license for your use. If you can't find royalty-free photos or can't purchase a license to use the photo, don't use it. A third common way that businesses often end up infringing someone else's intellectual property is by hiring employees who use someone else's intellectual property while performing work for your business. So for example, imagine that you hired an employee who used to work for Apple, and as part of his work at Apple, he gained significant knowledge and learned intimate details about how iPhones are designed. And then when you hired him, he started using this information to design phones for you that would compete with Apple's iPhone. If this happened, you could almost certainly expect a lawsuit from Apple, and you'd probably be found liable for infringing on their intellectual property. The way to prevent this is when hiring someone, make sure that the new employee does not have a restrictive covenant agreement with their former employer, such as a non-compete, a non-solicitation, or a non-disclosure agreement. If they do have one of these agreements, you can only hire them for roles where they are not likely to breach these agreements. And as part of your employment agreement with the individual, you should have a clause in your employment agreement that specifically forbids the employee from using anyone else's intellectual property while doing work for your business. The last pillar to protect your business is you want to institute the practice of clear, proactive communications with all parties and keeping good records. With respect to proactive communications, you want to address and resolve customer complaints and employee issues quickly and professionally. An unhappy customer who feels heard is far less likely to call a lawyer than one who feels ignored. And an employee who understands the why behind a decision is less likely to feel it was unfair. Also recognize that generally speaking, lawsuits are by their nature irrational. Almost nobody wants to file a lawsuit and nobody wants to be a defendant. They are expensive, time-consuming, public, and invasive. People only file lawsuits because they feel wronged in some fashion. Their feelings get hurt, and they get upset about the lack of response from the other party. For any potential issue that comes up, you should actively work to prevent the other party from getting too upset and dug into their position. And you should avoid getting too upset and dug in too. Almost all lawsuits settle before trial. So you should actively try to settle any potential issue before it becomes too expensive and before it becomes too late and a lawsuit is filed. With respect to record keeping, document everything. Keep detailed records of contracts, important emails, employee performance reviews, and customer complaints. If a dispute ever comes up, a well-documented paper trail created at the time the event occurred is your best friend. It can be used as evidence and preserves a record of what actually occurred for the future when memories fade. Building this fortress isn't a one-and-done job. It needs ongoing attention. If this information was valuable to you and you want to keep learning how to build a stronger, more bulletproof business, please make sure to hit the like and subscribe button below and turn on notifications. And let me know in the comments below which of these 6 pillars do you need to work on in your business right now. Sharing your own experience could help another entrepreneur avoid a disaster. So to summarize, the thought of a lawsuit is stressful. It can feel like a personal attack that threatens everything you sacrificed to build. But you're not powerless. You don't have to be a victim of circumstance like Sarah was. By focusing on these 6 pillars, strong contracts, the right business structure, business insurance, good employment practices, avoiding intellectual property infringement, and proactive communications and good record keeping, you can transform your business from an easy target into a well-defended stronghold. Proactive legal protection is an investment in your peace of mind and the future of your business. Don't wait until you get served a summons and complaint, and start building your fortress today. Thank you so much for watching, and I'll see you in the next video.